the Supreme Court has decided that the commission has primary jurisdiction over matters regarding municipal ordinances and how they apply to public utilities and public utility service. The state of the law is different today, given that decision, than it was in 2020. So of course the facts would not change. What happened, happened. But we may need different facts to explain and help the commission determine whether the ordinances Noblesville seeks to impose on Duke affect unreasonably Duke's ability to provide utility service. Duke had considered that this would be a docket before the commission like any other. We would file testimony just like we do in all other dockets. So Duke would file its testimony, the city and maybe Noblesville would file, let me flip that, the OUCC maybe, and Noblesville definitely would file their own testimony, with Duke then filing a reply. We would have a hearing, we would have a proposed order and post-hearing briefing, just as in any typical case.
Sorry, she's just sending me a message about the YouTube. And I guess this is like, in a moment you can, so Mr. Hughes, does Duke anticipate potentially filing a motion for summary judgment at all?
No, we did not.
Okay. All right, Mr. Hughes, I'll let you. I know, again, I know I'm kind of putting you guys on the spot since we didn't really talk about what we were going to do here today, but if you could let us know what Noblesville's position is, that would be great.
Sure, Judge. John Hughes, Bose McKinney & Evans, offices here at 111 Monument Circle here in Indianapolis. Been a long time since I've been over at the commission, but glad to be back. So this case, I guess a couple comments. This case was filed in 2020 by the city of Noblesville. I disagree with counsel's statement that the state of the law has changed. The argument that Duke made to the Supreme Court was the law has always been since Shively Spencer that these reasonableness questions come to the commission. We do have a Supreme Court decision that now tells us how we handle the two issues being filed at once. One should come here and one should go there. But the Supreme Court was very clear that Duke's counterclaims were a reasonableness claim, and that's what Duke argued to the Supreme Court. And Duke argued to the trial judge that they win as a matter of law on their counterclaims on summary judgment. We have both tendered a significant number of documents, which I provided to the commission in separate exhibits, just so it's easy to follow along with what is what. Duke filed over 500 pages of documents and affidavits. Noblesville filed somewhere around 300 pages of documents and affidavits, and the case has been pending for 4 years. The facts have not changed. So from our perspective, the question should be, do those facts establish that someone is entitled to judgment in this case as a matter of law? Duke said that it did originally. I know they say they're not going to file a motion here, but that would be the position we should look at first. And then if the commission believes there's issues of facts, then we can proceed with whether or not we need an additional schedule. But both the parties spent a significant amount of time, money, and resources in litigating this case for 4 years, and to reopen it up to just start all over effectively seems like a waste of ratepayer resources, taxpayer resources, and judicial resources. So we would object to, at this point, determining we need new evidence. I don't believe there's any issues of material fact. They demolished a house and they want to build a truck garage. So that's where we stand. So
Noblesville, you're thinking about summary judgment then. Are you planning to file summary judgment? Or?
We certainly could if that would help just clarify the issues.
And then OUCC's position is?
Thank you, Your Honor. As of right now, the OUCC is not taking a position regarding the schedule or admitting any evidence to the commission. We would defer to the commission on that subject.
So what I was thinking as far as when we do go on the record, what I think makes sense is for, again, I'll go down the line, and if you could just, and I can give you a moment to kind of collect your thoughts if you need to, just what is the schedule that you would like us to adopt? Like just in general, I mean, I think, I guess, you know, throwing out dates at this point may not make a ton, like, because you may not have thought about specific dates, but just if you know, have a general idea of what schedule that you would like us to adopt as far as like summary judgment deadlines, and we can even take, I don't know, 5 minutes if you want to take a moment to discuss.
We filed a proposed schedule in our petition.
Okay, yeah, you have
so
so you still are relying on that?
I mean, now a month has passed, so, and I'm open to extending that.
Okay, but that generally, that's what you still want to stick to? Okay. And then, Mr. Hughes, do you need a moment to?
I hadn't really given thought to specific dates. I'm happy to discuss those dates.
Well, maybe
Happy to discuss with Duke.
what may make sense, and I'll ask whether this makes sense, for if you want to talk about, you can give me a general idea of the order of operations, I guess, what you imagine happening, and then if you want to file an additional, like an updated schedule, and you want to file an updated schedule, say, by Friday or something, would that work?
Yes, we can do that.
Yeah.
Can do that,
Okay.
Your Honor.
Yeah, and then I guess OUCC still has.
Yeah,
a
that works
position.
for us.
Okay. All right. I think that should get us where we need to go today, at least, because we're not going to make a decision on this today. So, so I think that's it. Can you think of anything else? You're good? Okay. Linda, you ready? All right, so we're going to go on the record now. Let's go on the record. This is a pre-hearing conference and preliminary hearing before the Indiana Utility Regulatory Commission in a cause docketed before the Commission as cause number 46108, captioned as Petition of Duke Energy Indiana LLC pursuant to Indiana Code Section 812115, seeking the Indiana Utility Regulatory Commission to determine that the City of Noblesville's enforcement of ordinances interferes with Duke Energy Indiana's utility functions. Notice of the time and place of the hearing was given as provided by law by publication in Marion County in the Indianapolis Star on August 31st, 2024, in Hamilton County in the Reporter on September 2nd, 2024, and in Hamilton County in the Noblesville Times on September 4th, 2024, and in Hendricks County in the Republican on September 2nd, 2024. These are newspapers of general circulation, and these publications were made at least 10 days prior to the date of this pre-hearing conference and preliminary hearing. The proofs of publication of the notices have been received by the Commission and are now incorporated into the record of this cause by reference and placed in the official files of the Commission. Notice has also been given to the Indiana Office of Utility Consumer Counselor and other interested parties. May we have appearances, please?
Thank you, Your Honor. On behalf of petitioner, Duke Energy Indiana, Beth Hennigan and Ariane Johnson, 1000 East Main Street, Plainfield, Indiana.
Thank you.
Thank you, Your Honor. On behalf of the respondent, the City of Noblesville, Indiana, myself, Jonathan Hughes, from the law firm of Bose, McKinney & Evans, 111 Monument Circle, Suite 2700, and unfortunately, my co-counsel, Mr. Janak, also from the same law firm, was unable to attend today because he was sick.
Thank you, Your Honor. Appearing on behalf of the public, Matthew Kappas from the OUCC.
As we briefly discussed off the record, what I would like each of the parties to now do is kind of just give a general overview of what their position on the procedural schedule in this case is, and then we would ask that to the extent to propose a specific schedule and specific dates that the parties file a proposed schedule with the Commission by the end of the day Friday, which is September 20th. So I'll first start with Ms. Hennigan.
Thank you, Your Honor. Yes, Duke Energy Indiana is happy to file a updated schedule with proposed filing dates for testimony by Friday of this week. Again, as we stated while we were off the record, it's Duke's position that the Commission's authority granted to it under 81254 and 81269, those are the general investigatory statutes. The Commission is able to determine what evidence it may want and how it wants to proceed in this matter. Thank you.
Thank you. Mr. Hughes.
Thank you, Your Honor. I certainly agree that the Commission has the authority to proceed with any evidence that it thinks is appropriate. City of Noblesville takes the position this case has been pending for 4 years. During that time, the parties submitted a significant amount of briefing and evidence, and there's sufficient evidence in the record by Duke's own admission at the trial court to decide this issue on summary judgment. And so we would propose that the Commission consider the evidence that's been filed before it, which is the summary judgment record before the trial court, to make a determination on whether the ordinances unreasonably interfere. If the Commission would like additional briefing, we're happy to propose that, and I could propose a schedule on that briefing. After that decision is made, if there's a determination there's a genuine issue of material fact, then we could move into needing additional evidence, but I don't believe there are any genuine issues of material fact in this case.
Thank you. Mr. Kappas.
Thank you, Your Honor. Regarding additional evidence or the procedural schedule, the OUCC has no position and would defer that to the Commission.
Is there anything else that we haven't covered that we need to talk about on the record?
No, Your Honor, thank you.
Mr. Hughes?
Nothing from the city, Your Honor.
Nothing from the OUCC, Your Honor.
All right, we'll take this matter under advisement this hearing, and we, again, if you need to file, if you're filing a proposed schedule by Friday, which is the 20th, but we'll take this matter under advisement. This hearing's adjourned. Thank you, everyone.
Thank you, Your Honor.
Thanks.